Hello, everyone, and welcome to another Office Hours special show. You know, media technology is affecting everything today, and that is certainly a part of the legal profession. So that's the landscape we're heading back into as we welcome back Jason Kairalla. Some of you remember that he's been with us before, and you will recognize that he, as he did before, has generously assembled a great team of legal professionals to discuss media technology and litigation this time. Jason, welcome back.
Thanks very much, Bill. It's really great to be here. I just wanted...
Oh, yeah, go ahead.
Go ahead, please.
Well, I was just going to say, would you like to introduce our guests? We have an august legal panel tonight.
Absolutely. It would be my sincere pleasure. First, I would like to welcome and thank very much for being here Florida Circuit Judge Jason Dimitris. He came on last-minute notice at 9 o'clock at night here on the East Coast and dove into this panel for me. He is one of the most tech-forward jurists that I know. He is one of my favorite judges. Please do not tell all the other judges that we have to practice in front of. And he has some amazing points of view with respect to how technology is changing the way that trial practice happens. He's a former prosecutor, a great lawyer in his own right, and an incredibly experienced jurist. Next, I would like to welcome Willard Shepard. Willard may be the coolest guy that I know because in addition to being a lawyer, he spent 4 decades on television as an investigative journalist and news anchor. He has 6 Emmy Awards, which is fantastic. And he's also a retired U.S. Air Force pilot, and he kickboxes on the side. So he's a great lawyer. He has great insight with respect to the intersection between media and the law, and is just a person I'm very honored to call a friend. And last but not least, I'd also like to welcome Ryan Kairalla. Ryan is my younger brother, but he is someone that I look up to greatly. He is a music business expert. He is someone who has been hosting a podcast for almost a decade. And he's also very, very experienced in education law and a professor and a lot of other things, but operates a lot in the intersection between media and journalism as well. And I'm really happy to have him here. And for those of you who don't know me, my name is Jason Kairalla, and I've been practicing law here in South Florida for about 25 years. I'm also a technology enthusiast and a former head of legal innovation and technology at a prominent U.S. law firm.
Excellent beginning, and it is so great to have all of you here. For those of you who are watching maybe for the first time, we have a system where you can put questions into the show for our panelists. In a little bit, I'll give you some time to get your cameras out of your phones or something like that, because we will throw up a QR code. And that QR code will put you into what we call the Mukana interface that will allow you to not only put questions in for our panelists, but also vote those questions up and down. And that's how we determine what goes first and what we spend the most time talking about. Maybe we should start by looking at how technology helps the legal professionals prepare well before the trial, kind of start at the beginning of anything. Does anybody want to raise a hand and talk about how you see technology changing the process that attorneys and their firms and everybody else gets things done before you ever get to the courtroom? I'm not seeing any hands raised.
I'm happy to jump in with the first shot here, Bill.
Go for it, Jason.
There are places within the litigation world where technology has been around for a while. One of those things is the way in which we identify documents that are potentially responsive or relevant to a litigation, and then cull through them to find out how, what are the issues that the case is going to turn on, and to learn about the case before we proceed into discovery and things like that. And that's a pretty well-defined area. I would say since the pandemic, the use of video technology in court and in preparing for trial to go to court has been an area of tremendous development. I think, lawyers weren't participating in video conferences like this 6 years ago. And we thought it was just going to be a blip that, we would switch to video conferencing because of the pandemic, and then we wouldn't go back. But some visionaries like Judge Dimitris and others were saying, this may be actually a paradigm shift. And so we're here. So the way that we collect video evidence now through depositions and things like that, and the way we participate in interacting with our clients and with participating in live court proceedings has been changed profoundly by video in the same way that the folks here on Office Hours have been exploring that intersection in the digital media space.
I'm going to also imagine that the research you do ahead of litigation and things like that has been changed substantially by that, and perhaps things like testimonial aids, accident reenactments, so on and so forth. Anybody else want to weigh in on some of the other ways that technology helps today?
Yeah, I'll say that following up on that, prior to the trial and all of that in the deposition work here in this jurisdiction here in South Florida and into the county north of us, and two other jurisdictions here, our public defenders have been using a platform that can, in essence, give a live deposition so that our state attorneys, our public defenders, and this is pretty much true across not just Florida, but across the country, those people that are starting out doing that great work in communities across the country really have, they're overwhelmed. So any of this technology that can actually aid and help them become more efficient serves not just them, their case, the judges that they are going before, but also the entire community. And this particular project that started here in Miami-Dade County takes in depositions from regular citizens anywhere where they are. And think about a person who gets a subpoena to have a deposition to say, wow, I've got to drive downtown to go to the courthouse. You know, most courthouses are located in metropolitan areas across our country, in the downtown areas. You're talking about traffic, congestion, parking, all of those types of things, and they're unable to participate, or it certainly reduces the amount of participation. Whereas with this technology, it's done remotely. So a person can take a simple break from their job, get permission from their boss or supervisor, go in a break room, private place to be able to do that. And also what we've seen here in Florida, the police departments many times have their officers doing these either from a kiosk at a police station or a substation, or actually in their vehicles. And so the service time for them to actually do their police work is increased because they don't have to become so involved in all of the administrative aspects of getting to and from court. And it saves the taxpayers money as well because they're not paying overtime, those types of things. So it's been a tremendous benefit. And over the last year or so, when you combine all these jurisdictions here in Florida using this, there are about 30,000 depositions done here in Florida on this platform over the last year or so.
Wow, that must have saved an amazing amount of human hours, not wasting time traveling back and forth. Judge Dimitris, it looks like you, I saw you kind of move when that question was asked. Do you have something you want to weigh in on this?
Sure. At the risk of oversimplifying, I see our industry as lawyers, as an industry of communication and teaching and simplification. And especially given the fast pace we're all required to run at today in our industry, I believe technology is a tremendous asset in assisting us communicating clearly, accurately, and concisely. It also helps us prepare. So as Jason had mentioned in my introduction, I'm a fan of technology in the courts, and I'm a fan of technology in helping prepare the courts. And I regularly encourage lawyers to take chances on experimenting with newer technology. And I have a great deal of patience for that. Obviously, they have to do their due diligence and be ready, but things can go wrong when you're exploring that area. And I appreciate their attempts and the work that they do in presenting a case to me, utilizing technology and helping simplify, clarify, and reduce the amount of time it takes for me or the jurors to understand what those issues are.
Absolutely. Ryan, you do a podcast and you are on and off a lot. Do your podcast listeners, are they interested in this side of things, in the pre-trial preparation, and what do they talk about?
Well, on my podcast, my audience are primarily folks in the entertainment industry. These are entertainment industry professionals as opposed to legal professionals. That's the audience I'm trying to reach. And you might think when I talk about that audience, you're inclined to say, well, why would they care about innovations in legal tech? But I can think of at least one particular example where technology has allowed access to justice for entertainment industry professionals and has gotten them interested in this. Last few years, we saw the passage of the CASE Act in the federal Congress, which creates a small claims copyright court for low dollar copyright disputes. It used to be if somebody infringed your copyright and there wasn't a lot of money at stake, you were pretty much out of luck as a copyright holder because you were not going to find a lawyer who was going to take that case at such a small dollar amount. And this law, the CASE Act, was meant to create a small claims vehicle that could allow you to seek redress if somebody infringed your copyright. And what I think is cool about this law is one of the things that they did to make the justice accessible here is that the law specifically contemplates a video conferencing option for the small claims court, which I think is kind of a big deal at the federal court level. The federal level, particularly resistant to technological change, I would say. So to see them specifically have codified into a law, you need to allow people to seek redress specifically through video conferencing litigation, I think is really interesting. And the law is still very much in its early stages, and it's got a lot of kinks to work out before it kind of reaches its full potential in terms of implementation. But I could foresee, thanks to this legal tech innovation, a lot of my artist listeners having a way to get redress when somebody steals their copyrighted work where they wouldn't have otherwise had one.
Plus, with the proliferation of smartphones, it seems like a lot of society has now access to being able to use a phone or something like that to remote into a discussion like that or to something. Is that kind of what you're seeing, it making it easier for people to get that kind of access?
Absolutely. The technology is there through so many more means than there used to be. And I mean, even just the way you get counsel, I know this isn't directly related to legal tech, but I think it's an interesting point in terms of facilitating access to justice in this area. The law also contemplates allowing law students to represent litigants. So, if you can't afford a high-priced lawyer, there are going to be law schools that create clinics for this, where you can get a law student who probably knows a lot about this stuff because they've studied up on it and they're probably up on the latest trends in the entertainment industry. And you can get one of those people using these tech-forward legal resources through video conferencing to get you potential redress for a low dollar copyright infringement, and you wouldn't have otherwise had that opportunity.
Hey, Bill, if I could add in on
please do.
that.
Please do.
Just think about at the end of the day, what is our justice system and our legal system and the processes that we have set up in jurisdictions across the country? What are we actually trying to do? And that is to serve as many people as possible. And with this infusion of technology, we're able to interject this into people's daily lives so that they're able, if they get a parking ticket, to be able to use the technology. After all, most people are paying. If they got a violation on a parking ticket, it's probably because they use an app and the app expired, even though they're alleging, as I do sometimes, no, I was in that zone. I was in that proper zone. I put the right 4 to 5 digit code in there, and the app says, no, you weren't in that zone. You were in another different type of zone. But just think about literally the ability to be able to take the courthouse on a smartphone or an iPad or a Mac, wherever you are. And that is a tremendous leap forward. And I think, and the judge can weigh in here, there are only very few instances, and I would think that primarily in a criminal setting where you're talking about someone's liberty and their due process rights to look another person in the eye or witness in the eye, where Your Honor wants that individual right there in front of them. And he can address that. But the vast majority of times, that's not the case. And I think we should use this technology to bring the courthouse to the people that we're all trying to serve, rather than the other way around to make it difficult for them.
Judge, what say you?
Well, I actually enjoy teaching on this very point, where a lot of my peers will argue that for an important case, or for a case that requires credibility determination at even a specific and subtle level, that the hearing must occur in person for that determination to be appropriately made. And I like to do a training where the point of the training is to prove exactly the opposite. And those of you who have the ability to wander into a real courtroom, you may also appreciate the fact that oftentimes they are austere settings that are dark, that have bad acoustics, that have a lot of space between the trier of fact and the witness, whether that be the judge in relation to the witness, or whether that be the witness in relation to the jury. And my position is that I am a better assessor regularly of credibility via Zoom than in person. And I'll explain that, because when I am in person, oftentimes in a real courtroom, the witness that I'm assessing credibility on is sitting, and at best, I'm getting a profile of this person that is sitting beyond my legal books, beyond a screen, a monitor perhaps, and a wooden panel that separates the judge from the witness. Now, in a Zoom setting, I literally can reach out my hand and effectively touch what would be their nose on the screen. I can see their pupils dilate with certain questions. I can see their eyebrow twitch. And simultaneous to those questions being asked, I am also looking into the eyes of the person asking the questions. I'm looking into the eyes of the opposing party or parties, and I'm seeing their reactions. And I believe it puts me in a very good position to hear and see multiple people and determine credibility at a much higher level and more effectively than I was ever able to do in person.
Fascinating. And I also assume that for our citizens with hearing and or visual disabilities, that kind of evens the playing field in a lot of cases when they're part of these proceedings.
Oftentimes people with any kind of disability come forward with technology that assists them in the communication, and that too seems to work at a better level than the technology or assistance that they used to bring to a physical courtroom.
I don't want to open a huge can of worms here, but one of the questions that I had contemplated beforehand is how AI is supporting analysis of testimony and things like that in the law office itself. But it kind of opens us up a little bit about the how these new large language models and AI and just how much that is saturating society and how that affects courtroom processes. Does anybody want to weigh in on what they think is going to be the future of that, Ryan? Or Jason? Sorry, Jason.
I would say that generative AI has done more to push the legal industry into alignment with the rest of the world as far as technology goes. I would say pre-pandemic, we were 10 years behind or 5 years behind where I think business were in general. I found that lawyers and the legal industry and the clients are embracing generative AI in a way that I would not have expected going in, so I'll give you an example of something that we're doing with generative AI is that Willard was talking about taking these remote depositions where we can ingest the audio of the participants taking the deposition. Well, we can use speech to text technology to create a live transcript, to synchronize that to the video, to create video clips. But then on top of that, since we have the live testimony, we can also use generative AI to summarize it, to compare it against the trial plan, to point out inconsistencies with prior testimony. Like in that space, there's some really exciting things you can do. I'll add one other point that was surprising to me. I was up in Chicago for an American Bar Foundation meeting where all of these legal scholars, professors from all over the world were presenting papers on these issues. And one of the professors made this point that generative artificial intelligence is probably providing more legal services than all the lawyers in the world combined right now. And that's, was surprising to me, but I think it may also be true because there's large swaths of people who can't afford, to hire a lawyer. And there are some types of law where the lawyer is provided for you. But in the vast majority of cases, you can have no advice at all, or you can, lean into these tools and find information. So I think this is a world where we're pressing against what our framework is to make these things happen. Do we have the rules in place that we need to have in place? Do we need new rules? But I think the opportunity is incredibly exciting for lawyers and for clients.
I don't want to open another can of worms, but I was recently talking to a physician, and we got on the subject of how they deal with all the clients who attempt to self-educate on matters of medicine these days. And I have to imagine the same thing is happening at least a little bit in legal matters. Have any of you run into people who are now, chat GPTing their way and coming in and telling you how to operate in your area of expertise? That seems like a terrible set of circumstances to have.
Only every single one of my clients, Bill.
Yes. Only every single one.
But it's actually something I welcome. I tell my students all the time, one of the most important factors in a successful legal engagement is often not the quality of the attorney, but is the quality of the client. To the extent that a client is engaged, is interested, is knowledgeable about their industry, and is sophisticated, they're going to be able to communicate their legal issues to you better and be a useful partner in that legal engagement. And overall, I have found that my clients who use generative AI to help them organize their thoughts, to help them write things out, to get their ideas out there, to bounce ideas off of the AI, they come to me more informed and more sophisticated. Do they make mistakes? Sure. Is their reasoning often off? Absolutely. Do they tell me that I'm wrong because ChatGPT says that I'm wrong, and then I have to tell them why ChatGPT is wrong? Sure, but I have thick skin. That's fine. That's part of the back and forth. And if we don't want our clients kind of pushing back on us, like, we got to find a different profession. But I welcome this technology for the same reason Jason does. I think the positives and the opportunities far outweigh the negatives. And we do have to get over some of these fits and starts that we've seen. We certainly don't want lawyers putting hallucinated case citations into their briefs, as hopefully Judge Dimitris hasn't encountered one of those yet, but certainly we hear another story about that in a weekly basis somewhere in the country, an attorney doing that. We have to stop doing that stuff and let that stuff plague our profession. But overall, I love informed clients, and I love clients who have an opportunity to get their thoughts together before they talk to me. And if generative AI helps them do that, go for it.
Yeah, it certainly helps.
Deeper. Go ahead.
Bill, it certainly helps. Yeah. I'll say one of the things that we must balance with this, though, and we have a tremendous amount of rules here in the state of Florida, and the Florida Bar has been very diligent about all of the training that has been done, especially over the last several years. That's been a big primary focus of the bar here in our state, to make sure that those of us that are representing clients do it effectively, and do it with still some of the old school checks that must be done before matters are presented before the court or in your practice period. But I will say that in terms of clients pushing back in terms of the business side of the law, they look and say, well, wait a second, I did this with ChatGPT or whatever platform you're using, and I got an answer in 2 minutes. Why did someone send me a bill for an hour that is several $100s? My practice primary, based on contingency fees, so we don't generally get into that type of thing. But that's something that practitioners are facing here with this, and even clients who think that they know better, in a sense of and this is public record, but we will leave names out of it in specific professions. But I have 2 highly, highly, highly trained medical professionals who are defendants in an action that I have, who wanted to be their own lawyer. And I knew that the things that they were sending to me, despite their expertise in their profession, were going to get them in trouble down the road, and they did. And when they finally got legal counsel, I had the opposing counsel laughing on the phone, and I said, you and I aren't going practicing out any of this kind of medicine. And had the clients, your clients, not tried to practice the law, you and I wouldn't be on the phone.
Oh my gosh. Jason, I saw you nod your head there.
I would say answers are cheap. Correct answers are more expensive, right? When we talk about these rules and frameworks, you can plug a question into a generative artificial intelligence tool and get an answer back. That's good for you as a private citizen. But as a lawyer, I can't file that solution in court. I can't rely on what it says until I've independently verified it. And you don't want me to. The people who are getting in trouble with hallucinations, with citing things that are really fake or made up or whatever because the generative AI tool, told them it was okay. Those are lawyers who are not being diligent. Like, I can't take something that Ryan drafts and sign my name to it and file it until I'm independently verified that he does good work. I know he does great work, so it's easier for me to trust him than ChatGPT. But the fact of the matter is that, we have to be able to verify. And there's lots of different ways to do that. But just like if I'm working with a law clerk or an associate or an investigator or something, I have to make sure that I back up what I do. And people who don't, they risk that. I just want to also say, with respect to what Ryan said, I totally agree that bring me informed clients, and I'm happy to engage in discussion with them. And if they don't think that qualified legal counsel is worth the money, then they can go with Willard's client, with the person that Willard suggested, and try, going into court without a good lawyer.
Good luck in that circumstance. I said I was going to put up the QR code, so there it is on the screen now. For those of you who want to get questions into the queue, you can do that. And let's dive in. We have some of our questions coming in. Cindy Drozda is our question reader for today. Cindy, what have we got?
Here's a question for us from Josh Kaufman in Pittsburgh, Pennsylvania. When building trial visuals like animations and reenactments for court, what standards and steps help you win admissibility while keeping the story clear and not misleading?
Both Jason and Willard have raised hands on that, so we're going to go to Jason first. Jason?
Yeah, I will say there's a rule of evidence that basically covers this. If you're going to create a visual that helps the jury or the finder of fact understand testimony or evidence, it's important that it's made clear that it's not actually the evidence, right? But if the witness that's on the stand testifying says this visual is fair and it's accurate and it insists me in describing what happened and laying out evidence for you, and it's not too prejudicial or misleading, the court will allow it. And technology has changed in very significant ways how sophisticated those kind of demonstrative aids can be, right? It used to be like, I've got a whiteboard up here and I'm drawing an intersection or something like that, and that's your demonstrative aid. Now, and this actually has happened in a court recently, they went out with cameras and shot the scene of the crime or the accident scene with 3D video, and they encouraged the judge and the jury to put 3D headsets on, and they walked through the accident scene with narration from the witness. And they'll say, if you look to the left, you'll see this. If you look to the right, you'll see that. And because they met the standard of this rule of evidence 107, the court accepted that as a demonstrative aid. And I think that's really interesting. And I've seen some other experts. I was trying to have one on for today, but he unfortunately was in Amsterdam, and it's 2:00 in the morning right now. But he was describing how you could, show a three-dimensional image of a heart and show, how the valve was moving or whatever, if it was a medical malpractice case or something like that. Like, we can create these visuals, and they're incredibly powerful. And if a good lawyer knows the steps that they need to take to establish the record in front of the judge to have that be permitted to be used to aid testimony.
Willard, Shepard.
Yes, I would say while that's certainly the case, and Jason did an excellent job making it on the bottom line, making sure that whatever videos or animation actually represent what the evidence is, in the vast majority of times now, whether on the criminal side or even many times on the civil side, think about the society that we live in where a camera is virtually everywhere. Our police departments have body cameras. They have dash cams. There are cameras on our highways, roadways, in any private business, restaurants. So the vast, vast majority of this type of video evidence is actually, in fact, the evidence of what transpired because it is the realistic live depiction of what transpired. And that is fortunately most of what this type of area of work is. You just have to make sure that you can obtain it, that it is public record in whatever state you're in, or that you got a good set of investigators to be able to track down and get this evidence, even from Ring cameras. So many times, and it means so much. And one concern that I do have is that if a jury doesn't actually see this on video, whatever you're alleging, that if they then believe it not to be true. And that's a worry that I have. And Judge Dimitris can tell us what he thinks about that. But that's a concern that I have, that we've been so conditioned to now see all of this that jurors, if they don't see it, think that, no, it didn't happen.
Wow. Everything has to be a TV show, and the moment of truth has to be seen by all of us. Judge Dimitris.
Well, I appreciate what Willard and Jason have already provided. I did want to add an elementary level to this answer, which is one of my favorite trial tactics when I was a litigator, was to simply ask for a stipulation of the other side. So in direct answer to this question about the admissibility of any kind of visual aid, regardless of technology that's incorporated into it, just ask the other side. If they agree to it, then oftentimes a judge is going to allow it and not seek any further consideration. If they don't agree to it, then you've got your battle in front of you, but you haven't lost any ground there by asking for that stipulation up front. What I'm interested as a judge in the admissibility particularly is it going to be fair? Is it going to be unfairly prejudicial in some way? Is there something that's going to confuse or complicate things by a utilization of this visual that the other side is objecting to? But right off the bat, ask for stipulation. You'd be surprised at what you will get that way. Willard's question to me was another interesting piece that we're all confronted with today, which is trying to keep up with what TV lawyers and movie lawyers provide as an education to the public that's completely inaccurate, that every single case is going to be resolved in an hour, and that there are videos and audios of every single piece of the incident or crime. And that's just not the case. So the answer to that, I believe, is the lawyers educating the jurors. And even before that occurs, the lawyers picking jurors who are able to follow the law as the judge provides to them, as opposed to what they thought was the law that TV and movies have provided to them. That's our challenge. But we're educators as litigators, and I think we're able to do that. And I've seen that done very effectively.
You mean that the 1980s shows that always said just zoom in, zoom in, zoom in from a simple security cam, and you can't see the license plate clear as a bell? I'm shocked, I tell you.
We also have to say enhance.
Yeah, enhance. Oh, that's right. Forgot the magic words. Let's get to our next question.
Next up, we have Jeff Feely in Henderson, Texas asking, please discuss releases in regards to recording audio and video. Is there a need for a release when there are group shots?
Brian, this is right in your wheelhouse. Tell us what the rules are.
Sure. And the context is going to matter here, right? There are a wide range of ways where you could conceivably capture audio and video in a litigation or legal setting, whether it's recording people to use in some kind of technology that you're going to play in front of a jury during a trial, or just recording somebody for a deposition. Though I don't work regularly in litigation, my recommendation here would, if I were working with litigators on something like this, is the same advice that I give to documentarians when it comes to releases, which is an adage I like to say: you have to clear your nouns. What are nouns that we learned in school? Persons, places, and things. So any people, places, or things that are in your documentary, you have to make sure you have the rights to use it. If it's a person, it's a release, giving you the rights to use that person in your footage and having them waive all potential legal claims from that use. If it's a place, you're talking about a location release, so whoever owns that location approving you using their location. Or if it's a thing, whether it's like a photograph or a piece of music, making sure you've cleared all the related copyrights there and gotten a license to use the material. I would imagine the same principles would apply in the litigation setting. For a lot of these folks who are using remote deposition or recording deposition software, I would presume that a condition for somebody being able to be deposed on this software, they probably have to click some documentation that says that you approve being recorded for this and that it's going to be used in the trial and you're okay with that. And, in any other setting where somebody's footage or likeness is being captured, I imagine there's a release involved. And so I think the broader question is to err on the side, the broader recommendation here is to err on the side of getting everybody to sign off on whatever they're contributing to the project so you can avoid headaches down the road.
There's so much action so fast on this generative AI stuff. Are there special rules for that? I had heard at one point, I don't know if this is just apocryphal storytelling, but that something generative literally can't be copyrighted by somebody. Is that still true, or am I just totally misinformed?
We don't know yet.
Yeah, that's
the courts are still sorting that out, right? There's a lot of, because right now what you have is all of these LLMs are able to accomplish the great feats of brilliance that they give you, mainly because we've been feeding, trillions of terabytes worth of copyrighted material, whether it's newspaper articles, movies, TV shows. There are platforms like Suno, which can generate a song for you by you entering in a descriptive prompt that have been trained on copyrighted material in the form of every song that's ever been written or recorded. And so a foundational question there is, hey, isn't that copyright infringement? And, that's the courts, there's literally several pieces of federal litigation going through the system right now to dictate whether that is, basically an incalculable amount of copyright infringement in terms of damages, or if this is fair use. And how the law is going to come down on that question is going to have massive implications for the future growth of AI. In the music space, the approach seems to be that all of the relevant stakeholders are kind of just settling, right? They don't want the courts to answer that question. The AI companies don't want a negative ruling, and the recording companies don't want a negative ruling. So in a recent litigation, the labels have come to an agreement with platforms like Suno to create a opt-in royalty system where artists and copyright holders can get paid for their music being used to train AI. And maybe we'll start to see that proliferate more and more. Maybe we'll start to see some legislative solutions to this very significant problem. But until any of that happens, the answer is we don't know yet. And it makes all of this kind of the Wild West right now.
Jason, you wanted to weigh in on this?
Yeah, just a couple of points. One is the base of this discussion, which is I tell a tool to draw me a picture or write me a song. Courts have been looking at that like handing a camera to a monkey, basically. I can take a camera and I can claim some intellectual property rights off the picture that results from me pushing the button. If I hand a camera to a monkey, even though it was my idea to give the camera to the monkey, when the monkey presses the button and takes a picture, I can't claim intellectual property rights over that, and neither can the monkey. So the question I think we're really analyzing is generative AI like a monkey with a camera or something else? That's fine. I also wanted to make just a quick point about what Ryan said with regard to rights to a deposition. Generally, when somebody sits down for a deposition, it's because they're being compelled to do so as part of a legal process. Either they're a party to litigation, they get a notice, or they're not a party and they get subpoenaed. Their testimony is compelled, and its use in court doesn't require any kind of release. But they have a means if they don't want their video taken for some other reason. They can hire a lawyer and file an objection with the judge. And they can sort it out, but generally it's widely accepted in most states that you can take a videotape deposition and you can use it for purposes of using it in court. And once it's part of the public record, we just saw Jack Smith's, the special counsel to the United States. His deposition before Congress has been released and widely distributed as an interesting discussion, not to talk about the politics of it in general, but just it's an interesting glimpse into legal process if you wanted to take a look at it.
Let's get to our next question.
This is from panelist Jason Kairalla in Miami. What are other ways in which technology can improve access to justice?
And Judge, let's start with you.
All right. Well, I've seen firsthand great use of technology to improve access to justice. First of all, I was a juvenile court judge. I handled dependency, delinquency, domestic violence, and adult divorce cases in our complex trial division of family court in Miami. And with regularity, parents or witnesses were actually overseas. I recall numerous times that they were in the mountains in South America. And I recall that their children were in the United States and they needed to testify to provide the court with very critical information for the court to move forward in a way that would be in the best interest of the children. Now, in the old days, prior to the pandemic and prior to our use of Zoom, I recall parents in those situations telling me that they walked on dirt roads for more than a day in order to get to a major village where they could find a notary to be sworn in so that they could testify in court on the phone. And they had to pay this notary and they had to pay for that phone call. And it was extremely difficult to coordinate. And regularly, with our best efforts to coordinate, things would go wrong and I would not be able to receive that testimony. And that would leave us in a bind because unlike a civil case, if a party doesn't provide the evidence that they need, that might lead to a bad outcome on behalf of those that we really care about, which are the children. So I couldn't do without that testimony. Now, in the Zoom era, those parents from a mobile cell phone from their village with dirt floors in their homes, they were able to testify and answer questions, and I could even assess their credibility clearly and easily. By the way, the interpretation was better too through the Zoom platform and simultaneous interpretation. And I was able to, I believe, make better determinations on behalf of the children and at low expense to those parents. Now, in addition, technology has allowed a lot of our state employees to function and be more effective at doing their job rather than sitting in court waiting for their physical appearance and opportunity to testify. For example, I'll give you this point. Child protective investigators and child case managers, instead of waiting in court to testify, can be out helping children. And when the judge is ready for them, they can go to a room in the house with privacy or to a manager's office or to their car and testify. And again, I, as the fact finder in a family case, was able to make good credibility determinations, receive important information at a low cost to the litigator and to the parties, and also at a low cost to the taxpayer who didn't have to provide salaries for extra people, since so many would be sitting in the courtroom hallways waiting for their opportunity to testify. I could give 1,000 examples of how Zoom technology has improved access to courts. On a very regular occasion, I'll have parents, for instance, in a Burger King manager's office on their break testifying in the case, as opposed to them giving up their wages for the day to pay an Uber driver to get to the train, to get to downtown Miami, and paying childcare while they're away from home in order to for a 15-minute hearing. They would give up a day of wages, which oftentimes meant 2 jobs. So there are a lot of examples like that I would provide.
It's a great examples. It's so easy for those of us lay people to forget how much of a burden this can be on the average person when they're called in to deal with something like a family emergency.
Bill, if you don't mind,
please.
Something that might hit closer to home with a lot of the audience here.
Sure.
Is let's suggest for a moment that you, not you, Bill, but anyone listening is going through a divorce, and at that moment you have a motion that you think is a slam dunk that you want to get in front of the judge, and you call your attorney and say, get this motion in front of the judge, a 15-minute motion. I know I'll prevail. Can you do it? And the attorney might say to you, well, that judge is only allowing physical appearances. There's no Zoom appearance. And therefore, for me to go to court for this 15-minute hearing is going to cost you 2.5 hours, because it costs me an hour commute each way. So 2.5 hours is, what are we at here? $1,500, $1,250, something like that, as opposed to that same judge allowing that divorce attorney to appear electronically from their office while they're doing other work at their desk. When the appearance is allowed by the judge, they pop on. It's a 15-minute billable time. And so that's $125 instead of $2,000+. And I talked to some of my peers and I asked them, would the outcome be any different if the attorney presented in court versus by Zoom? And without exception, the judges have told me, no, the outcome would be the same, particularly on a simple, clear, winning legal motion. And yet look at that disparity in costs, and what are we gaining from requiring people to do that commute? And I know there are benefits for young attorneys to learn and interact with other attorneys, but if you're focused on the benefit to the clients and justice, then it's hard to argue that the in-person hearing would have merit in that situation.
Pretty big delta to try to overcome. Jason, you wanted to get in on this too.
Yeah, I wanted to discuss some other ways I think technology really helps. There are courts all over the country that are experimenting with a number of web-based self-help tools that parties can use, simple issues, small claims, landlord-tenant, things like that, where we're leveraging this technology with explanatory videos, with chatbots, with other things that helps someone without having to hire a lawyer to say, I have this simple legal need and I need some instruction on how to get it. And then another example is how you can use these chatbots and other tools like that to direct you to where legal services can be obtained, like through a legal services organization or other, not-for-profits or pro bono lawyers or things like that. And so lots of courts are experimenting with how you can do that. And I think that makes a huge difference. And I just wanted to bring back a point that Willard said earlier, which is the use of these remote depositions. And I'm going to specifically highlight what the Miami public defender is doing, where they're taking 25,000 depositions in criminal cases, mostly police officers and witnesses in felonies. And they're doing them all using digital technology, and they're doing them all remotely. And it means a police officer who used to have to drive to the civic center and park their cruiser and go up to the public defender's office and sit for a deposition, Now they're literally pulling their cruiser off to the side of the road. They're flipping open their laptop and they're participating in what is sometimes a 20 or 25-minute deposition. And when they're done, they sign off and they're right back on the beat. Like what that has meant to the number of times that the proceedings go forward, where in the old world they wouldn't have gone forward at all, like Judge Dimitris was saying, and the amount of time that our police officers and other government servants are protecting and serving the interest of the people instead of waiting around to be a part of legal process. I think that the value that has created for society is very difficult to calculate.
Let's go to our next question.
Brody Hefner in New York City asks the panel, how are artificial intelligence and large language models influencing the education and training of lawyers generally and litigators in particular?
All right, we've got a lot of people weighing in on this. I'm going to start with the judge.
Well, I'll tell you that I teach at the University of Miami Law School. And interestingly, we had a discussion on students who were using AI to prepare their presentations. And there was a split from the professors on whether or not that's appropriate. But I believe that the winning perspective, and I was in the losing perspective to give you that up front, the winning perspective was don't allow the students to use AI at all. And the perspective was supported by the facts that students need to learn how to do some of this foundational stuff on their own, or else they're not truly going to understand how to put these things together. And AI will never then help get them to their full potential if they don't understand some of the foundational building blocks. So even if you have a calculator in your hand, their perspective was you need to know how to do simple math in order to appropriately use a calculator to solve some of the bigger problems. And I think that's a very good supported philosophy. The other side of things are more along the lines of why are we building an artificial world for them that is not going to be their reality? And one of the presentations I like to make, I summarize by saying, look, you might be the winningest jockey in the world, but the automobile was just created. And so you better learn how to drive a stick shift and throw away your crop because nobody cares how fast you are on a horse anymore. So get the new tools, use the new tools, and figure out how to maximize what you're supposed to do as a lawyer.
Why does that resonate so much for me in this era? Thank you for that. Willis Shepard.
Okay, well, across town here, one of our rival law schools, that's my law school, at FIU here, the Florida International University. Jason and I have been there to basically try to begin a process where the staff there embeds some of this type of technology using depositions and other types of technology into the curriculum so that these young lawyers, when they finish, are actually prepared to use it. And they take it, and whether they're going into work with public defenders, state attorneys, they're going to work in our court system, or whether they're going to private practice where they're going to be junior lawyers in a larger firm, they're able to take this technology and then embed it and the benefits of it either in private practice or government service because they know how to use it. They've been on iPads and smartphones their whole lives now, and they're able to actually, in some cases, go into the senior partners at a firm and go, this is actually a good way to do this. Take a look at it and move all of this forward. So I think having this at our universities and at our law schools is a way for this technology to then jumpstart into the profession.
Ryan Kairalla.
There's not much more I can add beyond what my colleagues have already said. I think they've hit a lot of the main points. I mean, I would just want to just advance the idea that if the question is, how is AI and LLM knowledge and competencies being incorporated into the training of lawyers and in the continuing education of lawyers, I would just say not enough. Not yet. I mean, most of the CLE training that lawyers are getting right now when it comes to AI is kind of just the low-hanging fruit of when you use AI, make sure that you're not violating the rules of professional conduct. Yes, absolutely. But the more that we're just seeing legal education in AI as making sure you don't violate the prohibitions that you need to adhere to, as opposed to here's some education on how you can be using AI to empower your abilities as a lawyer and to serve your clients more effectively. The Legal Academy is doing the profession a pretty significant disservice. And it's early, right? I'm not going to be too critical of law schools yet of not embracing this more fully. But I do think that if we continue to adhere to the reasoning that Judge Dimitris did, where we say, well, we're not going to teach this stuff, we're not going to encourage this stuff yet because students still need to learn it the old way, eventually that becomes a cop-out. And we need to confront the fact that this is the way that lawyers are going to be practicing. And this is the way that many lawyers are already practicing more than we'll care to admit. And we need to make sure that these tools are being used responsibly and effectively.
Jason Kairalla.
I want to be very clear about this. I don't think it's just a good idea for lawyers to embrace generative artificial intelligence. I think they have an ethical and professional responsibility to do so. Competency with respect to technology and the ability to deliver services to your client in the most efficient and most effective way is part of our professional obligation. I'm not saying the answer is always generative AI, but I'm also saying the answer cannot possibly be never, right? Any lawyer that's sticking their head in the sand and saying, I don't understand it, I don't want to learn it, and I'm not going to use it to enhance potentially the results or outcomes for my clients or efficiencies that I can create for them or value that I create, I think they're not doing their job. And I think from an educational perspective, we have to equip lawyers of all ages, but particularly law students and young lawyers, with the ability to understand the full tool set at their disposal and to have the judgment to know where and when to exercise it. And a lot of the times that's the client's decision also. You can say, here's the incredibly traditional way, it's going to cost X. Here is the pure technology way, it's going to cost Y. Here's the in-between option. Here are the benefits and drawbacks of each. And then let the client, make an informed decision about that. With respect to how we can use these tools to educate, they are wonderful tools for education. And this doesn't just apply to law, but stop looking at the tool and telling it to do things for you, and look at the tools and ask them to teach you how to do things. And you will be amazed what you can learn.
We have one more question on the docket here.
This one's from Jason Kairalla in Miami. What can media production professionals do to assist lawyers and parties in litigation?
And it's Jason's question. I'm going to start with him. Jason, you want to clarify or add anything?
This is a question I'm putting out there because of the audience that we're talking to today. And the answer is there's so much that you can do, right? We have this ability when we are litigating to present arguments and evidence and to tell stories in ways that we never could before, utilizing video and media technology. And you guys here in office hours and on this call and watching on YouTube, you're the ones that know how to do that, right? And so I think there's an amazing opportunity to get involved in what's happening in the legal industry, to understand these developments, and then to be able to leverage your substantial expertise to aid lawyers in creating more efficient and more effective outcomes for their clients. So if you're interested in that discussion, and if you want to be a part of this and you want to engage with the legal community about this, we're going to be putting on more programming like this in the future, and I would encourage you all to get involved.
Judge Dimitris.
Well, very briefly, I would just say, show the lawyers and wow them with how you can simplify the points that they need to make and help them be persuasive in their arguments.
Willard Shepard.
Well, I'll put my journalist hat on here and say, I spent the bulk of my time in the career at NBC 3 decades. And in those 3 decades, when a person had an idea or they wanted to do something in this area or other areas, we were the ones that had the platform and a monopoly on it to do it, us and the other major networks. Now, anybody can do it. All you need is a smartphone. And that is a tremendous, gigantic leap forward that all people need to take advantage of and take advantage of right now, because it's an incredible opportunity.
Is there any last word that each of you would have on the panel? And I'll go around the horn really quickly that you want to pass out about the effect of all this technology and what it means and what people can look for that's brought down really simply. I'm going to start with Ryan Kairalla and then just kind of go through the panel. Ryan, what do you think is important here?
I think we need to have a sense of perspective when it comes to the potentially adverse impacts that people fear about the emergence of something like generative AI. I think most of the nightmare scenario that people in the profession are imagining is the wholesale replacement or end of law as we know it, and all the lawyers are going to be out of jobs. And I think like every new technology that enters the legal profession, it causes a reshuffling of resources and a change in the roles of lawyers and people who work in the legal profession, but it doesn't end the legal profession as we know it. And I don't think generative AI is going to be any different. I mean, I think the best example I can think of is when we started to see legal research databases like LexisNexis, and that was going to be the thing that, upended the legal profession. And it did have a substantial impact in that every law firm used to have a team of law librarians on staff. And those people largely got reshuffled into other roles because these platforms like Lexis and Westlaw could do the work of a team of law librarians. But, lawyers still worked. And because lawyers became more effective with these tools, the profession proliferated. I don't see generative AI as being any different.
Willard, Shepard, you're the next on my order of screens. What do you think?
Well, since everybody's talking about this, I'll make an analogy in the flying business. The Wright brothers flew about just a couple 100 feet, about 200 yards or so. The other night, we flew into a foreign land, turned off the lights, turned off the radio traffic, turned off the internet. Nobody knew that we were coming. We were able to come, do what we needed to do, and leave before anyone could do something about it. And that is the ultimate execution of the technology that we have in the flying business available to us now on the military side. This technology that we have in the legal business can do the same thing. We just need to take the steps forward to be able to, I hope, do the same type of brilliant execution.
Jason Kairalla.
Yeah, I'd be scared to think that this is, we're only at the having flown 300 feet part of your analogy, Willard, and we've got a very, very long way to go.
Right, brothers.
But I think that there's a profound opportunity to leverage this technology to create unbelievable opportunities for young lawyers and older lawyers and law students. People are lamenting the things which we have lost, but I would really like to focus on the things that we have gained, because I think the things we lose, we're going to adapt and find other ways to get by. But lawyers are working from home more than they were before. And so the opportunity to have mentoring in the office next to you and things like that are going away. With this digital technology, we have the ability to mass mentor, and technology first younger professionals have the ability to share their knowledge of this digital first world with more experienced lawyers, and more experienced lawyers and judges and law professors have the ability to leverage their knowledge, their deep experience in the practice of law and classical legal knowledge. They can share and impart that on a younger generation. And with these kind of tools, we can do it across the country and around the globe and at scale. And I think that is such an exciting time to be a lawyer. And I'm very happy to be one of the people that is thinking about this and working toward this type of future along with these other panelists. And I'm very excited to keep it going.
As is always appropriate, the last word goes to Judge Dimitris.
Well, thank you. As you know, I've made clear I'm an optimist with this technology. And I also agree with Jason that soon, if not already, a lawyer would not be considered as doing a sufficient job if they didn't incorporate some level of technology and AI into the work that they do. You can't explain to your client how you left something out if AI could have captured it quite easily and inexpensively and efficiently for your use. Now, with that being said, I don't know if it will surprise all of you, but I have already had several incidences where I have had to discipline lawyers who provided to the court hallucinated citation in their briefs to the court. Now, I have a soft spot in my heart for this occurring. Let me explain to you why. I can imagine, for instance, if I was an attorney in a big firm and I needed to provide a brief on a subject that had multiple different points, I might walk up and down the hallway and find another attorney who had already briefed some of those points and grab some of their paragraphs that have already been filed in other cases and incorporate those things into my brief and file that brief, worrying about the new areas of law that I had to address with my specific case, but being comforted that some of these other things I had to address have already been addressed by other competent lawyers in my firm and in the community, and I could just cut and paste their pieces right in there. Well, that's how easy it is for a hallucination to become part of your brief. You must look through every single piece of it to make sure that where you have signed off on something and provided to the court, that is a true and accurate and authentic research project that you can that you are willing to put your name to. The Florida bar, and I believe other bars across the nation, don't have any patience for a lawyer who allows a hallucination to somehow get incorporated into their argument to the court. So with that, I just wanted to caution you all because I do believe it could happen to almost anyone, and you have to be savvy enough to prevent that from happening to you. With that, I appreciate you having me here today, and I'm always happy to further everyone's interest and use appropriately in technology.
Counselors, we appreciate each and every one of you. Thank you so much for being a part of this, for coming on office hours and letting everybody who watches this show get some real human experienced answers to some of the questions that have come up today. I also have to thank some other people. For Cindy Drozda for being our question reader today. Thank you for facilitating everything going on here. And also to the back end crew that you don't see out there a lot, to Jeff, Josh, Alan, and Robert. This show does not work as smoothly as it does without you, so we appreciate that. We are going to come back and do more of these in the future. So you probably got this by checking on the specials Tuesday evening office hours schedule. Continue to do that, and you will see we'll come back with more of these, particularly if you like them. Ping us and let us know that you enjoyed this content. And that pretty much takes care of things for us. Thank you so much for being a part of the Office Hours evening program, this special show. This is Bill Davis signing off and saying thank you for watching.